Donald Trump's dirty DOJ tried to dismiss the case temporarily, what we call without prejudice. What does that mean? It means they get to bring the case back, revive it, re-indict it anytime they want, thereby holding it over Adams' head. And the presiding judge in the case said, wait a minute. And he appointed outside counsel to weigh in on whether this was the right thing to do or the wrong thing to do. And boy, did that outside counsel just weigh in. His opinion? Donald Trump's DOJ should not be allowed to hold those charges over Eric Adams' head. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, as you know, we have been closely following the criminal prosecution of New York City Mayor Eric Adams. He was indicted back during the Biden administration for really serious alleged public corruption crimes. And when Donald Trump won the election, his DOJ swooped in and said, wait a minute. We need Eric Adams to help Donald Trump in his political priorities, like immigration. Therefore, we want to dismiss Adams' case, but only temporarily, without prejudice, so we can hold it over his head. You know, make sure Eric Adams stays in line. Well, the presiding judge, Judge Ho, didn't seem to be persuaded that that was an appropriate thing for Donald Trump's Department of Justice to do. So he appointed outside counsel, amicus curiae, a friend of the court, to argue the opposite position, that, wait a minute, this doesn't seem right, holding it over the head of an elected official. And if you read today's headlines about what that friend of the court, that outside attorney, just said in his brand new court filing, you may be completely misled into thinking that this was somehow a win for the Trump administration. We see headlines like this one from USA Today. Lawyer appointed in New York City Mayor Eric Adams' case recommends dropping charges. Or this from the New York Times. Lawyer appointed in Adams' case says charges should be dropped. Friends, those headlines completely miss the point. Indeed, they miss the mark entirely, because the question wasn't whether the charges should be dropped or not. It was really whether the charges should be temporarily dropped so Donald Trump's DOJ can hold them over the head of Eric Adams, or whether they should be dismissed with prejudice so the Trump administration could not hold them over Eric Adams' head. That was really what was at issue, and we'll talk more about that in a minute. I have to tell you, friends, every day, seeing this kind of reporting, it reinforces my decision that I made a couple of months ago to go completely independent, 100% independent. I'm no longer aligned with corporate media, legacy media, mainstream media. I just try to call it the way it is. And to that end, I've gone over to Substack. Feel free to come on over to Substack and follow me, subscribe. You don't have to pay anything to find my content, because I don't put the content behind a paywall. You can subscribe financially and support my all independent efforts, but you don't have to. You can just go over, hit, follow or subscribe or whatever the right word is. You don't have to pay anything, and you can see all my content, 100% independent. Okay. So friends, as I scrolled through all of today's reporting on this legal development, this outside attorney brief that was just filed in the Eric Adams case, I think Politico came a lot closer to hitting the mark in this headline. Eric Adams' charges should be dropped permanently, court-appointed lawyer tells judge. In fact, friends, even a little more meat could have been put on the bones of that headline. Something along the lines of rejecting DOJ's attempt to temporarily drop charges. Eric Adams' charges should be dropped permanently, court-appointed lawyer tells judge. And here is how the Politico article begins. An outside lawyer appointed by the judge overseeing the criminal case against New York City Mayor Eric Adams advised the judge on Friday to dismiss the case permanently, rather than approve the Justice Department's request to abandon it for now while preserving the right to reinstate it in the future. Paul Clement, a prominent conservative Supreme Court advocate, wrote in a 33-page brief that the court has a limited but critical role to play in evaluating the Justice Department's efforts to stop prosecuting the Democratic mayor on corruption charges. Judges have no authority to force the Department of Justice to continue prosecuting a case, Clement wrote. But judges do have a role in approving how a case is dismissed once the Department of Justice has decided to abandon it. In the Adams case, the proper remedy is a permanent dismissal, Clement told U.S. District Judge Dale Ho. Allowing the Department of Justice to retain the right to revive the charges could create an appearance of improper leverage over the mayor, Clement suggested. Or, he acknowledged, it could create an actual shakedown in which the administration could use the threat of the charges to pressure the mayor to assist with President Donald Trump's agenda. Ho appointed Clement last month to present adversarial arguments on the department's bid to abandon the charges against Adams. Ho does not have to follow Clement's recommendation. The extraordinary effort by top Trump administration officials to stop prosecuting Adams sparked a crisis in the Justice Department. Emile Beauvais, then the department's acting number 2 official, ordered the Manhattan U.S. Attorney's Office, which brought the case, to drop it, and to do so without prejudice, a legal term meaning the charges could be refiled. Beauvais' order triggered a revolt inside the Department of Justice, prompting the resignation of Danielle Sassoon, who was the interim Manhattan U.S. Attorney, and several other top prosecutors in New York and Washington. In her resignation letter, Sassoon alleged a quid pro quo between the Justice Department and Adams, in which the charges would be dropped in exchange for the mayor's help with Trump's agenda, particularly regarding immigration enforcement. In his brief, Clement took aim at Beauvais' argument that prosecutors should retain the ability to bring the charges again in the future. That scenario, Clement wrote, would create a palpable sense that the prosecution outlined in the indictment and approved by a grand jury could be renewed, a prospect that hangs like the proverbial sword of Damocles over the accused, that being Mayor Adams. Now, friends, in my opinion, Politico got the reporting and perhaps most importantly, the headline right. And this recommendation made by the outside attorney, the friend of the court, the amicus curiae, Paul Clement, if adopted by Judge Ho, would not only be a loss for Donald Trump's Department of Justice, but it would be a rebuke of what they were trying to pull here. You know, look, Eric, you be a good little mayor, because if you're not, if you step out of line, if you don't do what Donald Trump wants you to do to help him out with his political priorities, boy, we will bring this criminal prosecution roaring back against you. So what are the next steps? What can we expect moving forward in this case now that this brief has been filed by Attorney Paul Clement? Well, I, for one, hope that the next thing we see is an evidentiary hearing. I'd like to see Judge Ho say, okay, now I have to decide whether to dismiss this case with prejudice or without prejudice. And as Attorney Clement's new court filing makes clear, part of the decision that is up to Judge Ho is what is in the public interest here. And so I hope he puts people on the stand, people like Emile Beauvais, who get examined and cross-examined on what was really going on behind what looks pretty transparently like a quid pro quo, because the evidence is there was no factual, no evidentiary problem with this prosecution. There was no legal or legal theory problem with this prosecution. They just wanted Eric Adams to help Donald Trump in his political priorities. That's an unethical quid pro quo. That's not a good reason to dismiss a criminal case, a public corruption case, somebody who has apparently violated the public trust of the people of New York. So Judge Ho has every right. Indeed, I would think he has every incentive and every reason to hold an evidentiary hearing. But we'll talk more about that when we hear from Judge Ho about next steps he's contemplating in the case. And friends, I want to finish up with a little surprise, a little nugget, a little Easter egg even, that is buried in the middle of Paul Clement's brand new 33-page brief that he filed in the Eric Adams case. And let me set this up. The question in this litigation was never whether Judge Ho would be able to entirely deny the Department of Justice's efforts to dismiss Eric Adams' case and force them to prosecute it. That's not feasible. It's not realistic. Why? Because DOJ could just say, yeah, we're not going to prosecute it. We'll let the speedy trial clock run and the case will end up being dismissed one way or another. That's one impediment to Judge Ho refusing to dismiss the case. But the other is that the judicial branch of government, the judiciary, the federal judges, don't have prosecutors available to them. They don't have independent prosecutors such that if Judge Ho denied the motion to dismiss Eric Adams' case, he could just pluck out an independent prosecutor and say, I want you to prosecute Eric Adams. There is no such vehicle available to the judiciary except in one instance. And this is something that is relevant today and will become more relevant tomorrow and the next day and the next day. And it has to do with what happens when someone is held in contempt of court and the judiciary, the federal judge, wants that contempt case prosecuted, and the Department of Justice, the executive branch, says, we're not doing it. You see where I'm going here? Friends, if the Trump administration begins to defy court orders and, Trump administration officials or Donald Trump himself are held in contempt and there needs to be a contempt trial, they need to be prosecuted for criminal contempt of court, you can kind of see that one coming, right? Trump is already setting up his, refusal to abide by court orders in any number of cases. Well, there is that little Easter egg, that little nugget in the middle of this new court filing that addresses that very scenario. Arguably, it didn't really have to be in here as part of resolving the issue in the Eric Adams case, but it's in here. Let's go to page 15. There is no express authorization for the courts to take over a prosecution or to appoint a special prosecutor to maintain a prosecution that the executive, meaning the Department of Justice, the executive branch, wishes to abandon. But there is one narrow context in which the Supreme Court has recognized that a court has authority to exercise what would otherwise be a core executive branch function, a DOJ function. It is long settled that courts possess inherent authority to initiate contempt proceedings for disobedience to the court's orders, authority which necessarily encompasses the ability to appoint a private attorney to prosecute the contempt. Indeed, the Supreme Court has upheld it as essential to ensuring that the judiciary has a means to vindicate its own authority without complete dependence on the other branches. In other words, if the executive branch, if the Department of Justice won't pursue a contempt for somebody who intentionally violates federal court orders, the courts need to have a remedy to vindicate the court's rights. As a particular case, the Young case, explained, if the judiciary were completely dependent on the executive branch, the Department of Justice, to redress direct affronts to its authority, it would be powerless to protect itself if that branch, the executive branch, the DOJ, declined prosecution. Friends, hold fast to what we see on page 15 of independent attorney Paul Clement's brief, that a contempt of court can be pursued independently by the judges if the executive branch refuses to pursue the contempt and refuses to abide by lawful court orders. That is an important inherent power of the judiciary. And can't you just see those battles brewing on the horizon? Well, it's a darn good thing that the courts will have the ability to deal with contemptuous Trump administration officials.